enforced, and those who are to benefit from the laws can get the benefit. So all matters dealing with the cyberspace must be able to reach beyond the territorial jurisdiction to where the harm is committed. And the Parliament of Jamaica has the power to do so under the Jamaica Independence Act, which is one of our constitutional instruments. That is the extent of my contribution on this.
Minister without portfolio in the office of the Prime Minister, let's make welcome to his feet, Minister Wheatley. Will now make his contribution to the debate.
Thank you, Madam Speaker. I'm closing the debate.
Sorry, he is closing the debate.
Thank you very much, Madam Speaker. I rise to close this debate on the Cybercrimes Amendment Act. And I begin by thanking members on both sides of this honorable House for a serious, thoughtful, and practical discussion during the sitting of last week, January 22nd. And of course, the contribution from the member from St. James West Central just now. The issues raised go to the heart of public trust and public safety in an increasingly digital society. Madam Speaker, I will address the concerns and the recommendations raised by the members who spoke last week and this week. The member from St. Mary's Southeastern, St. Andrew Southeastern, Portland Eastern, St. Andrew Southwestern, St. Andrew Southern, St. Elizabeth Northeastern, St. Anne Southeastern, St. Catherine Southeastern, and just now the member from St. James West Central. Madam Speaker, this bill is not being brought lightly to this House for us to deliberate and vote. It is being brought because the harm is real. Fraud and scamming, identity theft, cyber-enabled deception, and the non-consensual sharing of intimate images are damaging lives, families, businesses, and confidence in the digital society. And the government's obligation, Madam Speaker, is to ensure that our laws keep pace with these threats without losing the sight of rights, due process, and clear prosecutorial standards. Madam Speaker, members from St. Mary Southeastern, St. Andrew Southwestern, and St. Elizabeth Northeastern asked why Jamaica has not acceded to the Council of Europe Convention on Cybercrime, commonly called the Budapest Convention. Madam Speaker, the House should note that Jamaica has signed the United Nations Convention against Cybercrime, and we will therefore be a member of an international treaty framework on cybercrime and international cooperation. Madam Speaker, the Budapest Convention was developed by the Council of Europe and signed in November 2001. It was the first international treaty addressing crimes committed via the internet and computer networks. While it has grown to include many members globally and has influenced the shape of cybercrime laws worldwide, including our own, they remain an important context. It emerged from a drafting process led principally within Europe, and a number of countries rejected it and advocated, Madam Speaker, for a new international convention developed through the United Nations. Madam Speaker, in 2019, following a United Nations resolution to adopt a new convention, another committee was established to elaborate a comprehensive international convention on countering the criminal use of information and communications technologies. Pardon me, Madam Speaker. The UN Convention Against Cybercrime was developed on December 24, 2024, and opened for signature on October 25, 2025. Jamaica played a significant role in that process, and along with some 71 other countries, signed the UN Convention Against Cybercrime on October 25, 2025. Madam Speaker, the UN Convention provides a comprehensive approach to prevent and combat the global problem of cybercrime, to include, Madam Speaker, human rights safeguards, strengthening international cooperation, and establishes extensive measures for technical assistance, capacity building, and information exchange. Madam Speaker, this is, of attention for us to, especially countries like Jamaica, where developing countries would need to get that level of support to build the capacity within our own jurisdiction to challenge or to deal with issues like this. Madam Speaker, the key point is this: international cooperation is not optional in cybercrime enforcement. Whether through existing mutual legal assistance arrangements or through the UN Convention framework as it becomes operational, Jamaica is positioning itself to secure the cross-border cooperation that gives domestic law real enforcement strength. Madam Speaker, several members raised concerns about Clause 5, which amends Section 9 of the Principal Act. Suggestions to remove nudity, intimate images, are broken beyond that harm, Madam Speaker. The Honourable Member for St. Catherine South Eastern suggested removing nudity or intimate images from the bill, while the member from St. Anne South Eastern suggested expanding the clause to cover other harms caused by generated images. Madam Speaker, the House is reminded that these amendments arise from the work and the recommendations of the Joint Select Committee established to review the Cybercrimes Act. And one of the specific issues considered was that what is commonly referred to as revenge porn. That is the non-consensual sharing of intimate images. Madam Speaker, Clause 5 speaks directly to that issue. For that reason, the suggestion to remove intimate images cannot be accepted, and the clause is not drafted to cover every conceivable harm that a generated image might cause. It is targeted, Madam Speaker, because the harm is specific, severe, and widespread. The member from St. Anne South Eastern raised the lack of provision for audio, noting that deepfakes can also be used for voice cloning. Madam Speaker, Clause 5 creates an offense regarding the publication of an intimate image, a visual representation of sexual activity, nudity, or partial nudity. That is why the focus in this instance is visual, Madam Speaker. I know that the House can appreciate that audio representation could not be contemplated within the specific offense being created in this clause. Madam Speaker, the member from St. Andrew Southwestern and St. Andrew Southern expressed concerns that reputational sabotage and the broader misuse of one's image and biological manifestations have not been fully addressed, especially in this current age where AI is becoming so prevalent. I must admit that the government side here, Madam Speaker, acknowledges the seriousness of this concern. Whoever the House is being asked to note that the Cybercrimes Act must not be viewed in isolation. Publication of false material, as the member from St. James West Central alluded to earlier. Reputational harm, misuse of personal data or biometric misuse must be addressed within the wider legal framework, including the Defamation Act and the Data Protection Act. Madam Speaker, under the Data Protection Act, biometric data is treated as a sensitive personal data, and written consent is required for its lawful use. That, Madam Speaker, provides rights to prevent processing where it is likely to cause a substantial harm or substantial damage or distress and is unwarranted. Madam Speaker, concerns were also raised, especially by the member from St. Elizabeth Northeastern, that the bill does not expressly reference artificial intelligence, deepfakes, forged documents, or manipulated videos, and that this may make prosecution difficult. Madam Speaker, we have to be very real how we deal with issues like this, because the House must recognize that the Cybercrimes Act is technologically neutral. That neutrality, Madam Speaker, is very much intentional. It allows prosecution of offenses under the Act, irrespective of the technology used, the platform involved, or the method of manipulation. And I will repeat, it allows, Madam Speaker, for the prosecution of offenses under the Act, irrespective of the technology that is being used, or the platform involved, or the method of manipulation. The absence of a specific reference to AI, Madam Speaker, is therefore not fatal. What matters is whether the required elements of the offense are present, whether an intimate image is created or generated, and whether relevant fraudulent manipulation of data has occurred through input, alteration, deletion, suppression, or other means contemplated by the Act. Madam Speaker, this notwithstanding, the government has already indicated its intention to develop a national AI policy, Madam Speaker. Yes. And we have reappointed the National AI Task Force to assist with this work, including, Madam Speaker, analysis of Jamaica's legal and regulatory framework and recommendations for new laws or further amendments. Madam Speaker, members from St. Andrew Southern, St. Elizabeth Northeastern, St. Catherine Southeastern, and St. Andrew South Western raised concerns regarding certain defenses proposed in Section 9. Specifically, Madam Speaker, the publication to the individual depicted in the image. Again, it was also raised by the member from St. James West Central. Publication for bona fide educational, medical, scientific, or research purposes, and publication for reporting about historical events. Madam Speaker, the offense contemplates publication to persons other than the individual depicted, meaning the public, Madam Speaker, or a third party. This is why a defense for publication to the individual depicted was included. Madam Speaker, with respect to publication for bona fide educational, medical, scientific, or research purposes, members are reminded again that the Cybercrime Act is not to be applied in isolation. Any use of an individual's image must still comply with laws such as the Data Protection Act, the Defamation Act, the Obscene Publication Suppression Act, and the Child Pornography Prevention Act, Madam Speaker. Madam Speaker, the Data Protection Act requirements are consent, particularly written consent for biometric data, remains very much relevant. On the issue of historical event, the concern is very much appreciated. The intention is to distinguish between current events and events of historical significance. Madam Speaker, the government does not consider it prudent to define historical event in the statute, but the ordinary meaning is clear. An occurrence from the past that has significant meaning or impact on society, culture, politics, or the economy is what we would contemplate to be historical. An event from last week, Madam Speaker, is not a historical event. It is a current event. So we have to view it in real context, rather than just opposing for the sake of opposing. It is something that as a society, as Jamaicans, we have to be real, because we know what is current and what is classified as historical. Spanish Town becoming the first capital in 1534 was an historical event. But the fact that you go on social media and hide behind a device, whether a computer, a laptop, or a smartphone, and you go and defame someone or you produce something that causes harm to someone's reputation, that is not an historical event. It's a current event, and you are to be held liable. Yeah. Turn from the mic. I show you here, Mama. You see, that's why you were clapping the desk. You heard. Madam Speaker, the honourable member from St. Mary Southeastern encouraged future tightening to address cumulative and organized digital misconduct and platform cooperation in fraud investigations. The government agrees with the thrust of this point. The House is reminded of the role of the major organized crime and anti-corruption agency, MOCA, in investigating and prosecuting serious organized crime, including cybercrime, Madam Speaker. In addition, law enforcement agencies will collaborate through existing mutual legal assistance arrangements, and as Jamaica advances its position under the UN Convention framework, will be able to access international cooperation, technical assistance, capacity building, and information exchange to strengthen investigation. I believe, Madam Speaker, that addresses the concern of persons committing crimes against Jamaicans and are hiding overseas. We have seen in recent times a lot of persons, especially when it comes to election time. You see some people creeping out from some holes. In some instances, we see where there are paid partnerships. And that, again, Madam Speaker, can be investigated to see where Madam Speaker, the point is that they cannot hide from the law. Whether you're from Westmoreland, St. Catherine, New York, Kingston, Even if you're in Algeria, the law will find you. And I'm not speaking, Madam Speaker, to any of the honorable members in this house. I'm just saying areas where one might believe that they can find comfort, security. So if you go to Portland, if you go to Haiti, the law will find you. Madam Speaker, the member from St. Andrew Southeastern raised the concern about the time taken to 2 years, in fact, to review, and of course the period before tabling. And it is indeed a real concern, Madam Speaker. The government acknowledges this concern. But it should be noted, Madam Speaker, that cybercrime reform is not a simple drafting exercise. It requires careful alignment of enforcement powers, prosecutorial practicality, constitutional safeguards, and coherence with other laws. Especially, Madam Speaker, where the amendments touch issues like consent, privacy, public interest reporting, and sensitive data, Madam Speaker. That said, Madam Speaker, the government accepts the broader point. Technology moves quickly, and the law must not be allowed to move slowly. And we are committed, Madam Speaker, to more continuous review rather than the long cycles between updates. The honorable member, or should I just say the member from St. Andrew Southeastern, raised the issue of underreporting of cyber incidents, including within the financial sector, and stress the importance of reporting incidents to regulators. A very good point. And it's an observation that we fully support. The Cybercrime Act itself does not create breach notification duties. So this is where now we have to teach Julia. The Cybercrime Act, and is also the spokesperson. And the Cybercrime Act itself does not create breach notification duties. We acknowledge that. But Section 21 of the Data Protection Act imposes obligations on data controllers to comply with data protection standards and to report to the Information Commissioner within 72 hours. Any contravention of that standard and any security breach affecting or which may affect personal data must be reported. That is an obligation, and I know the member appreciates that because he participated in the whole process. He participated in the process, and we have to ensure that we raise the standard here in Jamaica, where data breaches are reported in a timely manner. We have seen in a jurisdiction where there are data breaches that the data commissioner or the regulator is notified, as well as the person whose data was breached. The Data Protection Act provides that level of support and coverage. We have to now put in place the necessary enforcement to ensure that where there is a data breach, in whatever sector, financial or otherwise, that proper reporting is done. Madam Speaker, data controllers also have an obligation to notify the subjects, as I stated earlier, whose personal data is affected. And so this is a key reminder to institutions. Cyber risk is not only a technical matter, it is also a compliance obligation, and it carries legal consequences. So institutions that collect data, personal data, must recognize that they do have an obligation. And where there are breaches within their institution or organization, there is a reporting mechanism that is automatically triggered, and they must comply. There are very stiff penalties under the Data Protection Act. And when an institution decides that it wants to operate in this space, they must recognize that they have an obligation to protect our data and cannot use our data without consent. Madam Speaker, the member from St. Andrew, Southeastern, encouraged that the 2015 guidelines published by the Office of the Director of Public Prosecutions regarding the interpretation of Section 9 be included in public education. The government agrees. Madam Speaker, a law is only as effective as public understanding and enforcement readiness. And so proper public education must be done. And if we want to ensure that a number of our laws, in particular sensitive regulation and laws, are fully appreciated, we have a responsibility to ensure that we have adequate public education as well. We cannot just pass laws and expect people to comply. We have to ensure that the laws that we pass for the benefit of our people, that they themselves are aware of their own obligation and the consequences that will follow. Laws cannot be created in isolation. It must be done in such a way that our citizens appreciate the work that is being done to protect them. And that is why I truly agree that public education is essential. And so, following passage, we will embark on an education and awareness program to ensure citizens, institutions, and law enforcement agencies understand the provisions of the Act, the practical standards, and the consequences of breach. Madam Speaker, the member from Portland Eastern asked how enforcement would define the person in control of premises and whether that person can control any act under the Cyber Crimes Act. Madam Speaker, the member from St. and Southeastern also suggested mandating reports once the location of criminal activity is known. Clause 8 gives effect to the recommendation of the Joint Select Committee and is akin to a provision in the Law Reform Fraudulent Transactions Special Provisions Act of 2013, commonly called the Lotto Scam Act, Madam Speaker. Section 5 of that act penalizes the owner, occupier, or person responsible for management of premises who knowingly causes or permit the premises to be used for commission of offenses under that act. Madam Speaker, it is our understanding that law enforcement has not faced difficulty identifying the persons or persons responsible for management under the Lotto Scam Act. And we expect similar practical clarity here, Madam Speaker. With respect to monetary reporting suggestions, the government notes the point and will consider it as part of continuing reforms. Madam Speaker, ensuring that we build obligations that are enforceable and consistent with existing legal duties and safeguards. Madam Speaker, the member from St. Andrew Southwestern expressed that the penalties are inadequate. The House is asked to note that the Act provides for prosecution in both the parish court and the circuit court. This creates limits at the parish court, level, but more seriously, Madam Speaker, but more serious consequences at the circuit court level, where fines may be at large and imprisonment ranges significantly depending on the offense, damage caused, and whether it is a repeat offense. For protected systems where interference would have debilitating impact on national security, public services, or public safety, the Act provides penalties up to 25 years. I believe the member will appreciate the fact that 25 years, which in technical term is a lifetime, is more than sufficient at this time. Technical lifetime. Technical. The government's view is that the penalties are substantive and sufficient, while acknowledging that deterrence is not only about maximum penalties. It is also about detection, investigation capacity, and successful prosecution. Madam Speaker, the issue of spam was raised. And I'm going to define spam as I will also define key later on. Spam is really defined as the unsolicited bulk messaging or messages which can oftentimes be a nuisance. Not yet.
Madam Speaker, the member's time having expired, we ask that it be extended by 10 minutes.
The question is that the member's time be extended by 10 minutes to allow for the completion of his presentation in closing the debate. Those in favor?
Aye.
Those against? The ayes have it. Minister? Please turn on your mic, Minister.
Thank you very much, Madam Speaker. Thank you, colleagues. So, Madam Speaker, the issue of spam was raised earlier, and we all can appreciate that spam messaging can be a nuisance. It is also a gateway for malware, phishing, and financial scams. Jamaica already addresses spamming through multiple laws. The Electronic Transaction Act of 2007, the Data Protection Act of 2020, and the existing Cybercrimes Act of 2015. Madam Speaker, unsolicited commercial communications, direct marketing restrictions, and related cyber harms are already covered within this legislative ecosystem. This bill, Madam Speaker, does not need to replicate what is already covered elsewhere. Instead, Madam Speaker, it strengthens critical gaps identified through review. And I must, thank the members and the participants who work during the review process, members from both sides of the aisle, and the contributions that we got from the public and interest group that has brought us to this point where we can really table and debate the amendments. Madam Speaker, the member from St. Andrews Southern sought clarification on the distinction between the terms electronic and digital in the context of the amendment to the definition of key in clause 2 and 11. Madam Speaker, in modern cybersecurity practice, particularly within public key infrastructure, the PKI, a key is not simply a physical object. It is not the key that you use and start your car. And in fact, we stop using the keys that you insert in car. Right, member? It is also digital. It's not you, it is the member beside you. It refers to cryptographic key material used to control access, protect confidentiality, and verify identity through encryption and digital signatures. Madam Speaker, in today's online world, a key often means the secure code or credential that proves identity, unlocks access, or protects information such as the credentials used for secure logins, encrypted communications, and trusted digital signatures. So, to simplify it, a digital key, and I'm not going to be specific as to who I am addressing. No. A digital key refers to the secure credential itself, the unique code that enables security and trust online. An electronic key, refers to the electronic device or mechanism that may hold or use that credential, such as your debit card, your credit card, a token, or other electronic tool used to access systems securely. Madam Speaker, the purpose of the amendment is to ensure the law clearly covers both the secure credential card and the way it is stored or used so that offenders cannot exploit a loophole. And so it was in that context that we redefined the term key relative to it being digital or electronic. And as the technology evolves, we will have to also, in time, redefine terms that now broadly covers the area. And as I don't know anything about anyone offshore. Don't draw me into that. Madam Speaker, members raise concern about investigative capacity. While operational capacity sits within the relevant agencies, the bill strengthens procedural discipline and accountability by requiring the Commissioner of Police to develop and implement a code of standard procedures for search and seizure under Section 18. Madam Speaker, this is very much practical and necessary. In fact, complex cyber cases often succeed or fail on lawful, consistent evidence handling. In addition, Madam Speaker, through international cooperation and technical assistance mechanism, Jamaica will continue strengthening training and capability across the investigative and the prosecutorial chain. Madam Speaker, the member for St. Andrews Southwestern recommended empowering the clerk of court to seize computers engaged in fraudulent activities. Madam Speaker, the House is reminded that investigative search and seizure powers reside within the Jamaica Constabulary Force, not the prosecutors. The bill, however, makes provision to improve the forfeiture process by enabling the clerk of courts to make an application for forfeiture of already seized computer material. This supports better case outcomes, Madam Speaker, and stronger disruption of criminal operations. In closing, Madam Speaker, this bill is fundamentally about protecting Jamaicans in a borderless digital world. It's about restoring and reinforcing trust. Trust in digital banking, trust in digital commerce, trust in online communications, and trust in the ability of the state to defend citizens against modern harms. It addresses, Madam Speaker, real and present dangers. The non-consensual sharing of intimate images, the rise in scams and fraud targeting families and businesses, the misuse of digital tools to deceive, extort, and exploit. It strengthens enforcement while recognizing safeguards and the wider legal framework that protects rights and personal data. Madam Speaker, this is not anti-technology legislation. It is pro-trust, pro-safety, and pro-digital confidence. Jamaica cannot build a modern digital society or a modern digital economy if the public believes, Madam Speaker, that the digital space is lawless. Madam Speaker, I believe I have addressed most of the concerns raised, and I commend this bill to this honorable House for a second reading.
As a perennial victim myself, the question is that the bill be read a second time. Those in favor? Those against? The ayes have it.